Chapter Xi. The battle continues. Battle of Short Creek. On July 26, 1953, Governor Howard Pyle of Arizona commenced a massive raid on Short Creek. He had given $50,000 of state funds to the Attorney General and declared the right-bracket fundamentalists in a state of insurrection. A literal army of over 200 law enforcement men and other personnel were mobilized for the attack. The Attorney General, state troopers, deputy sheriffs, a dozen liquor inspectors, judges, welfare workers, juvenile court officials, doctors, nurses, policewomen, and even the National Guard all combined to administer justice under martial law to these outlaws. Most of the leading newspapers throughout the nation were notified and present in the raid. Even many of the European newspapers were represented with the exception of Russia. This wasn't news to them because they always do things in a similar manner. The Short Creekers had already received word of what was coming and had posted a sentry near town. When the governor's army drove down the road at 4:30 a.m. on that Sunday morning, the sentry blew off a charge of dynamite for the signal. The motorcade dashed into the dark and dusty community with guns drawn and ready for shooting, only to find the inoffensive inhabitants standing in the churchyard singing America. The state militia was embarrassed but not outdone, as officers chased after the children, pushed women into cars, and solemnly arrested an 85-year-old man, with two of his sons, who had just arrived home the night before on furlough in the service of their country. The boys in the uniform of their country were embarrassed and disgusted at what was happening to their hometown. They expected to see such things only in foreign lands. The elderly Joseph Smith Jessup died soon after the raid, and his 281 children, grandchildren, and great-grandchildren said his heart was broken because the state had ruined their settlement. Right-bracket Short Creek, Arizona, July 1953. State officials interrogating a Short Creek mother at 4 a.m., July 26, 1953. A military police camp was established to feed and guard the Short Creek citizens. Right-bracket mothers with their children were separated from their homes and husbands before any of them had been proven guilty of any crime. Arizona had just become a police state. Women and children were herded off to the juvenile officers like cattle or slaves. The Short Creekers could have left before the raid, but they preferred to stay and defend their rights. The Constitution of the United States forbids Congress from making any law respecting the establishment of religion or prohibiting the free exercise thereof. Therefore, the fundamentalists wanted to know, by what law is our property confiscated and attempts made to sell what can be sold to pay our fines, before we have been tried in a court of law, proven guilty, or sentenced? Truth 18:108. Among the rights of citizens are those rights for the pursuit of happiness of our own choosing. The children chose to stay with their parents, but the law was going to force them into foster homes. Tears from children and parents had no influence upon these officials. But there would be a reckoning because Jesus had said, "Whosoever shall offend one of these little ones which believe in me, it were better for him that a millstone were hanged about his neck, and that he were drowned in the depth of the sea." Matt. 18:6. Over a dozen men who witnessed this raid and who had served in the armed forces in Europe said they saw the same tactics used by the Gestapo. There was no law on the statute books of Arizona against plural marriage, so some were invented to make up complaints against the Short Creekers. So many law officials were involved that it has been said only 9 officers were left on duty in other parts of the state. For 26 months Governor Pyle had been planning this attack. 39 fundamentalist men were taken to Kingman. Within 2 weeks they were released on bail to await trial. When they returned to Short Creek, they found a silent city empty of their families and friends. 86 women and 263 children had been taken to Phoenix, and some of the older women had been taken to the Kingman County Jail. The officials of the state of Arizona planned to put all the children into foster homes, give prison sentences to the parents, and destroy or remove the houses, the dairy, cannery, sawmill and agricultural buildings that belonged to the community. This was the governor's device to prevent the re-establishment of homes in Short Creek. It was a plan to destroy the practice and teaching of the doctrine of plural marriage. But behind all of this, it was beginning to appear to be an object for political aggrandizement. The people of Short Creek had just celebrated Pioneer Day, a day of appreciation for those early pioneers who believed in the same doctrines and had forged an empire in the West as a heritage for those who loved the freedoms of America. Then came the pile drive against them. Tax money that was paid for the protection of citizens in their God-given rights was now spent in breaking up the homes of citizens. Pyle said he was going to protect the children of Short Creek, but he tore them away from their parents. These people were called conspirators and insurrectionists, but it was Pyle who conspired to tear a whole community apart with his own insurrection. Citizens were hauled off to a jail 400 miles away, while national newsmen made hysteria worldwide. The whole campaign was a political scheme for publicity of personal favor and fame. But Pyle's balloon popped and his prospects were soon reversed. Most of the news media began to turn against the governor and his exploitation program. The editor of an Arizona newspaper wrote, "An artificially created cloak and dagger script typical of Hollywood's worst product was followed by state officials at Short Creek. A veritable army of law enforcement officers roared into the tiny village in the dark of the moon. Bristling with guns, they swept into the homes of misguided women and children. In fact, the raid on Short Creek and its polygamists was planned and carried out in an atmosphere that would have made Mack Sennett and his Keystone Cops green with envy. The only life they know has been disrupted in a bewildering raid that resembles too closely the hated police state roundups of the old world. By what stretch of the imagination could the action of the Short Creek children be classified as insurrection? Again we say officials of the state of Arizona have humiliated its citizens by a pistol and shotgun raid that resembled an operation to subdue Pork Chop Hill. Insurrection? Well, if so, an insurrection with diapers and volleyballs. The Arizona Republic, Phoenix, Arizona. From the front page of another newspaper came the following. But Governor Howard Pyle and his own Attorney General Ross Jones appear to have looked the other way when the civil rights of the citizens of Short Creek, Arizona, were involved. It is a pity that the truth about Governor Pyle's hunger for publicity, which will cost the taxpayers of Arizona more than $600,000 before it ends, has been hidden from the voters and others of Arizona. The United States Supreme Court has time after time ruled no one has a right to take a person's papers without proper and legal authority but that did not stop the armed raiders, led by Attorney General Ross Jones and instigated by Governor Howard Pyle. He had to have his publicity no matter who was hurt, who was destroyed. Yes, communistic Russia and China moved into Short Creek the morning of July 26, 1953. Is that not the story we read about Russia and China? The mothers of the children who were and are legally married under the law of the state of Arizona were browbeaten, intimidated, and told their children would be taken away from them, and they would never see them again. Oh, you may say so what maybe, that's why we are losing our rights so readily is, because unless it hits us as individuals, the average person just does not care. But that was how Hitler, Mussolini and Stalin became possible, the apathy and so what attitude of the citizens of Germany, Italy and Russia. Then it became too late. Arizona News Reporter, October 22, 1954. The raid had soon become even more political than it looked. An election was coming up and all this exhibition and ceremony boomeranged to become political suicide for Governor Pyle. Even state and federal officers got burned for the way they handled the citizens at Short Creek. One editor said the Short Creek community merits a full measure of censure, but not destruction. Why such a circus? Another editor wrote, "Aside from the human side of the situation, think of the cost to the taxpayers. Each of the 122 persons charged must be given a fair trial. A jury panel of 70 persons for each trial must be drawn and paid for. The person selected cannot serve on the next case. That would mean 122 separate trials. As far as we are concerned, it is just a cheap publicity stunt the way it was handled, and a costly one." Graham County Guardian. The fundamentalists, of course, were outraged, and Joseph Musser wrote, "In reviewing the history of Missouri and the recent raid upon the innocent of Short Creek, one would suppose that Governor Boggs, together with his friends Governor Ford of Illinois and Judge Douglas, had been temporarily released from the infernal regions to brief their modern co-conspirators, and to assist them with the proceedings." Truth 19:98. Although millions of American citizens were roused against such an uncivilized attack upon a helpless people, the Deseret News expressed the mind of most of the Mormon leaders, as it applauded Governor Pyle and his Nero-type police state tactics. Law-abiding citizens of Utah and Arizona owe a debt of gratitude to Arizona's Governor Howard Pyle and to his police officers who Sunday raided the polygamous settlement at Short Creek and rounded up its leaders for trial. Again, we commend the governor for his forthright efforts. We have full confidence that the rights of the innocent will be protected, the accused will be given a fair trial, and we hope the unfortunate activities at Short Creek will be cleaned up once and for all. Day. News, Monday, July the 27th, 1953. A governor in Utah later said that this raid had disturbed the conscience of most Americans, even those who previously had no regard for the Short Creekers. He said there is something in the heart of every American that becomes riled up when any sort of influence strikes against a man's home and his family affairs. Loyal Americans will not tolerate that kind of interference and despotism to the home and family. At the time of the raid, Governor Pyle boldly took all the responsibility and glory, but months later he wanted to wash his hands of the whole mess. It is ironic that for all the international publicity given this raid, these men spent less than 2 weeks in prison. On November 30, 1953, the 27 men of Short Creek were sentenced by Judge Robert S. Tuller in Kingman, Arizona. The judge decided they should not be given heavy sentences of imprisonment because, he said, imprisonment for you would make martyrs and heroes of you in the eyes of others who are inclined in the same direction. The sentence of the court was as follows. Gentlemen, it is the judgment of the court that you are guilty of the crime charged, and it is the order of the court that the imposition of sentence upon you, the court names each of the defendants individually, be suspended until December 1, 1954, upon the following conditions. First, that you shall violate no laws. Second, that you and each of you shall report once each month by letter, over your signature, to Mr. Charles F. Adams, the Chief Probation Officer of Mohave County, here at Kingman, or his successor. Your letter must be mailed so as to reach him as nearly as possible on the first day of each month, commencing with the 1st of January, 1954, and under no circumstances later than the 5th day of each month. In your report you shall state what your residence address has been for the past month, and whether you have been continually at that address. In the event that you have changed your residence during the month, you shall so state. It is also required that you state whether you plan to change your residence during the following 30 days, and, if so, to where. Lastly, it will be required that you state, in writing, that you have not practiced polygamy during the preceding 30 days. I think it is not necessary to define the word to you, I think you all well know what I mean. This requirement is a token of my respect for you. It would be meaningless to require it of the ordinary offender. I believe, however, that you are all men of honor, and I trust your word. A violation of the conditions of your probation by any one of you will mean that upon December 1, 1954, or at any date prior thereto, in the discretion of the court, the violator, the individual who violates the conditions of his probation, will be sentenced to imprisonment. Closing remarks of Judge Robert S. Tuller, November 30, 1954, Kingman, Arizona. On file at the county courthouse in Kingman. However, at a later date 9 of these 27 men were accused of violating one or more of the terms of this probation. Leroy Sunderland Johnson, Daniel Calvin Jessup, Louis Jessup Barlow, Joseph Israel Barlow, William Benjamin Cook, Warren Elmer Johnson, Carl Nathaniel Holm, Clyde Chapman Mackett. Lynn Hunter should have been Lynn Cook. Possibly because of insufficient evidence, however, these men were not subsequently imprisoned. It is interesting to note here that during all the court trials, threats, accusations, brief incarceration, etc., imposed upon these men, the court records never indicate that any of these men signed a statement denying their belief in the principle of plural marriage in order to obtain a lighter sentence, or be released from prison or their probation. The mothers and children also suffered for their support of this principle. For nearly 2 years children lived in foster homes, and mothers were unable to return to their homes in Short Creek. In January of 1954, the parents of these children received the following letter from the Washington County judge, offering them a test oath compromise so they could regain possession of their children. January the 26th, 1954. To the parents of Short Creek, Utah. At the conference held at Short Creek January 25, it was represented to the court that the Utah parents are not now either practicing or teaching plural marriage, and that families are appropriately segregated. However, the court was given no assurance that this state of affairs would continue beyond the time the fathers are under suspended criminal sentence, imposed by the Superior Court of Mohave County, Arizona. The cases were all set for trial on March 25, 1954, and the parents concerned given until February 25 to submit to the court sworn statements to the effect that they would forever desist from practicing polygamy and teaching the doctrine to their children, and that they would otherwise comply with the laws of Utah relating to marriage and sexual offenses. If these statements are submitted to the court and the court is satisfied that polygamy is not being practiced or taught to the children, and that the parents are otherwise complying with the Utah laws relating to marriage and sexual offenses, then the cases will be continued to a date certain for further observation. If this procedure is followed by the parents, further sworn statements will be required from time to time as to present and past conduct of the parents, until the court is satisfied from the statements and investigation that there is compliance with the law. If sworn statements are not submitted to the court by February 25, then those cases will be heard on March 25 or as soon thereafter as possible. The parents will be permitted to retain actual custody of their children only if sworn statements are submitted at the time judgment is entered and periodically thereafter, and the court is satisfied from investigation that there is at all times compliance with the laws relating to polygamy, marriage and sexual offenses. It is almost inconceivable that you would be willing to compromise your beliefs in order to avoid a 1-year prison sentence for the fathers, but would not be willing to change your ways for the sake of your children. How could this be justified? It is up to you to decide whether you will comply with the law or will force the court to take the action outlined where the unfitness of homes is proved. Yours very truly, David A. Anderson, Judge. CSL Tribune, page 24, March 25, 1954. The judge received no statements from any of the parents after his order. When questioning Mr. Leroy Johnson, the judge said, "Are you going to risk the prospect of losing custody of your children?" Mr. Johnson solemnly replied, "It looks as though we'll have to." No one can fully understand this situation unless he has experienced such unjust treatment. One mother told her story, which was printed in an Arizona newspaper. An Arizona Short Creek mother's experience. A mother says, "We had seven daughters, two being twins at the time of the raid. After holding us in armed custody, they gave me about a half hour to get ready to leave. They told me I would be gone only a few days. We were placed in a bus. It was raining and cold. The children were frightened, so was I. I was pregnant at the time. We reached Phoenix and we were placed in a so-called rest home. They placed six mothers and 29 children in one room and hallway. There was one toilet available for all of us. We were kept under these unhealthy, unsanitary conditions for 3.5 months. It was terrible. We were allotted three cots for the eight of us. At home in Short Creek we had a two-story house. To take care of seven daughters I needed so many things, which they simply ignored. The authorities. Their reason and excuse being it was all for the welfare of our children. Was and is that what they call welfare? Here it is October 1954. We were taken from our home in early August 1953. I'm kept separated from my husband. They still refuse to allow us to go home. Oh, so many times I've been threatened they were going to take my children away from us. My husband and I are properly and legally married. I've been advised about eight months ago there was filed a petition for a writ of habeas corpus. But here we are still under the control and custody of the State Welfare Department. My children cry for their father. I need the comfort and help of my husband. We are ordinary people. At home our children were raised on fresh milk from our own cows and goats. We keep asking ourselves, why? We were bothering no one at Short Creek. We moved to Short Creek and were living there a little over a year when the armed raid took place. We are bewildered, confused. It seems the only way we can or ever will receive justice is for a change in the administration of things." One famous case involved Leonard and Vera Black. Their children were taken from them because they would not conform by signing the state's thought control affidavit along religious lines. A few attorneys became so disgusted with such injustice, they entered the arena to recover the children. The State Board of Education in Arizona also got into the limelight. 3 Short Creek teachers, Clyde Macker, Louis J. Barlow, and Gerald Williams, were indicted and required to sign the following oath before July 31, 1954, or they would lose their teaching certificates. It read, "State of Arizona. County of underscore 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 I underscore 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 do solemnly swear that I will not live or engage in polygamy or plural marriage from this day forward. Subscribed and sworn to before me. This underscore 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 day of underscore 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 comma 1954. Underscore 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 notary, public. If they refused to sign this oath, it would mean the death sentence to their teaching career not only throughout Arizona, but also in every other state. Louis J. Barlow answered the State Board of Education by saying, "I cannot denounce my religion with hopes of eternal progression for such a trivial reward you have to offer." Gerald Ray Williams also wrote them and said, "If I should sign this, your special, extraordinary religious test oath, I would violate a previous oath I made to uphold the Constitution of Arizona and the Constitution of the United States." Many others wrote letters of protest. Richard S. Jessup added his contempt of such proceedings by saying, "It is a sad commentary upon our American educational system that those who are the foremost leaders and who are the most learned in the scholastic fields could be so lacking in statesmanship and moral courage as to sign their names to such an obviously unconstitutional demand as a special religious test for certain teachers in our state. Is not the time-honored right bracket oath to support the Constitution of the United States and the Constitution and laws of the state of Arizona sufficient?" Richard S. Jessup. The day had arrived in America that citizens were being required to sign oaths to conform to the policies of officials, as well as to their own private beliefs regarding religion. Thought control was becoming a law of the land. But Article 6, Clause 3, of the United States Constitution states very clearly that no religious test shall ever be required as a qualification to any office or public trust under the United States. Article 2, Section 12, of the Arizona Constitution clearly states that no religious qualification shall be required for any public office or employment. But now they were. It is a disgrace that common citizens of America have to present the fundamental constitutional laws to the attention of its learned officials. Such tyrants are only prompted by religious bigotry. The greater crimes were not committed by the victims, but by the persecutors. Official villains were corrupting the courts, shattering the Constitution, and bringing abuse upon the rights of men, women, and children by such illegal prosecutions.